This is Colin O'Keefe here with Monday's episode of LXBN TV. As expected, Canning v. NLRB is headed to the Supreme Court. In the much-discussed suit, the D.C. Circuit ruled that President Obama's recent appointments to the National Labor Relations Board were unconstitutional. Joining us to break down the latest is Mark Theodore of Proskauer and their blog, Labor Relations Update. Mark, first, what's the latest? What happened to kick this case up to the Supreme Court?
That's a good question. I think really what you're seeing happening, Colin, is that the NLRB had no choice but to take it up to the Supreme Court. I think that there was a split in the circuits, and the only other choice they really had was to appeal to a wider panel of the D.C. Circuit. And I think that they looked at their chances and thought maybe that wasn't such a good idea.
Yes, definitely. This is a big decision that many people will be looking ahead to. Do you have any forecast on which way this might go once it's up at the Supreme Court?
You know, it's very difficult to tell because it's not really, it is strictly a constitutional question, and you can, I think, predict with some certainty how some justices will vote on it. I would say this. I would say that I think the D.C. Circuit did a very, very good job of uncovering at least the universe of what was out there, and how that'll be interpreted is anyone's guess, but it's sure to be close. I can predict that.
Absolutely. All the people I've talked to about this case say the D.C. Circuit did a good job evaluating it and that their reasoning was sound, so it'll be interesting to see what happens at the Supreme Court. So say the Supreme Court does indeed side with the D.C. Circuit and that the recess appointments are struck down. Will that result in turmoil considering how active the board has been since those appointments, or is the drama surrounding this a bit overblown?
You know, I think it's probably somewhere in between. Look, it will create chaos for sure because the significance of this particular decision is we already know that what happened with New Process Steel, which was the two-member board case from before, that all of the decisions were nullified, but none of them were actually none of them disappeared. The board just went back and affirmed most of them, and I haven't done a head count, but I would say probably 99% of them they just rubber stamped and affirmed. And so the case, if somebody has a case before the board, it's not going to go away. But what's going to cause turmoil is the level of uncertainty that's left. Certainly a lot of precedents have fallen in the last couple months. That's one. Two, the regulations concerning the election process, the secret ballot election process for employees, are dependent on this board, on what would be effectively a two-member board if the Supreme Court affirms. And so those will disappear. But really, when you drill down to it, the bigger thing that's causing chaos is this board made a lot of other decisions. They appointed regional directors. Those regional directors made decisions. So there's a cascade effect. Is it overblown? Probably not as bad as everybody says it is, but it's pretty unstable.
Absolutely. This is going to be a huge case to watch in 2013. I don't know if the drama is overblown surrounding it, but if it isn't by much, as this could have a very big impact.
Absolutely.
Again, that was Proskauer's Mark Theodore. For more of his insight as he tracks this case, be sure to visit laborrelationsupdate.com. And for even more on this case, we actually have a section dedicated to it at LXBN.com with tons of curated insights. So just search for Canning v. NLRB and then click on that tag for the dedicated section. Thanks for joining us, Mark.
Thank you for having me, Colin.